Hello everyone, this is Suresh Ramani here. In the video today, we are going to take care of and talk about Article 14 of the Indian Constitution. It states, the state shall not deny to any person equality before law or equal protection of laws within the territory of India. Note that this is applicable to all individuals and not necessarily only the citizens of India. And the state here means any governing body. It could be a local municipality or a state government or the central government. These provisions correspond to the equal protective clause of the 14th Amendment of the USA Constitution. Article 14 outlaws discrimination in a general way and guarantees equality before law and equal protection of law to all persons. Two concepts are involved in Article 14. First is equality before law, and second is equal protection of laws. Let us understand these concepts. Equality before law is a negative concept which ensures that there is no special privilege in favor of anyone, that all are equally subjected to ordinary law of the land and no person whatsoever be his rank or condition is above the law. This, however, is not an absolute rule and there are a few exceptions to it. Example is Article 361, which gives immunity to the president and the governors. Judges and public servants also enjoy some protection. The second concept, equal protection of law, is positive in nature. It does not mean that identically same law should apply to all persons and that every law must have a universal application irrespective of differences of circumstances. What Article 14 states is equality of treatment in equal circumstances. In Jagannath versus UP, the Supreme Court observed it implies that among equals, the law should be equal and equally administered, that the like should be treated alike without distinction of race, religion, wealth, status, or political influence. All persons are not equal by nature or circumstances. The legislature is required to deal with various problems arising out of huge variety of human relations. It must therefore necessarily have power to make laws for attaining particular objects and for the purpose of distinguishing, selecting, and classifying persons and things upon which the law is to operate. Thus, a legislature is entitled to make a reasonable classification and treat all in one class in equal footing. Article 14 ensures equality, but it does not, however, operate against rational classification. Classification to be reasonable and rational has to fulfill two tests. First, it should not be arbitrary, artificial, or evasive. It should be based on an intelligible difference which distinguishes persons or things grouped together in a class from others left out. Second is the differentiation adopted must have a rational or reasonable relationship to the object. So every law has certain object. Okay, so whatever differentiation the lawmakers have, it should relate to the object being served. When a person seeks to challenge the law on the ground that it violates Article 14, the burden is upon him to plead and prove this. the initial presumption is in favor of validity of law normally. The working of the above principles may be illustrated with a few important case laws. First, let us look at Bombay versus Balsara. Here the courts ruled that even if there are some restrictions on consumption of liquor for general people, it is valid to exempt military mess and canteens from restriction on use or consumption of liquor, because military has its own tradition and mode of life, and there is understandable basis of classification. Next, Madhu Limaye versus Superintendent Tihar Jail. The food served to European prisoners was much superior to that served to Indian prisoners. The courts ruled that difference between Indian and European prisoners in the matter of treatment and diet violates Article 14. Next, PP Enterprise versus India. Here the sugar dealers in Calcutta were permitted to keep a maximum stock of 3,500 quintals of sugar, whereas those in towns with population of more than 1 lakh were permitted 250 quintals, and in towns with population of less than 1 lakh were permitted 100 quintals. The courts ruled that such classification of dealers was held valid based on reasonable classification based on the population. Law applicable to a single person. A law which is based on a reasonable classification will not become invalid merely because the class to which it applies consists of only one person. A single body or institution may form a class under special circumstances. This is highlighted by the case PV Shastri versus India. The Prime Minister is allowed the use of Indian Air Force plane for non-official purposes, but not so the leaders of other political parties. This is not discriminatory because of the special status and duties of Prime Minister. He is a class by himself. Next, Bira Kishore versus Orissa. A special law passed by Sri Jagannath Temple was held valid as the temple had a unique position among Hindu temples and so could be given special treatment. Next, let us look at West Bengal versus Anwar Ali with respect to special courts. Here, what was involved was a Bengal law permitting of setting up of special courts for speedier trials of offences or class of offences as the state government might direct by a general order or a special order. These courts were to follow a procedure which was less advantageous to the accused than the procedure of normal courts. The act was held as invalid as it made no reasonable classification or did not lay down any yardstick for grouping either persons or offences so as to distinguish them from others outside the purview of the act. The act gave uncontrolled authority to executive to discriminate. Something similar was there in Kathi Rani Rawat versus Saurashtra, but here the act was held valid as there was a policy stated in the preamble to the act, and that the government was expected to select such offences for trial in a special courts as were calculated to affect public safety, public order. So very specifically, if something was concerning public safety and public order, they would be only coming under this act. Discrimination by state in its own favor. Article 14 does not outlaw discrimination between state and private individuals because the two are not placed on the same footing. Thus, creation of a monopoly by state in its favor will not be bad under Article 14. Tax laws enjoy more judicial indulgence because picking and choosing within limits is inevitable within taxation. Example is various slabs of income for taxation under Income Tax Act. The courts adopt a more tolerant attitude towards tax laws because of the complexity of taxation and fiscal adjustment of diverse elements. Article 14 primarily guarantees against arbitrariness and inhibits state action, legislature or executive, which suffers from the vice of arbitrariness. Every state action must be non-arbitrary and be reasonable, else it will be violative of Article 14. Article 14 is no longer to be equated merely with the principle of classification. It is primarily a guarantee against arbitrariness of state action, and the doctrine of classification has been evolved as a subsidiary rule to test whether a particular action is arbitrary or not. If the law or the state action is arbitrary, it would be violative of Article 14 and is liable to be struck down. Now with that, friends, that was a short brief on Article 14. Please share your views in the comment section. Over the next few episodes, I will cover other important parts of the Constitution. Thank you for watching and have a great day and a great year ahead.